Good afternoon, everyone. Welcome to the litigation update. Just waiting for folks to join us. This is our last brown bag for the year, so it's really great to see you all. We are lucky to have today not two, but three speakers today: Mark Murkami, Greg Kugle, and Na Lan, all directors at Damon. As you know, Mark and Greg have done this brown bag for many years, and I'm grateful to them and Na that they agreed to present the litigation update again this year. After today's presentation, we'll have a short Q&A. You can drop your questions in the chat, and our presenters will answer as many as they can during the Q&A session. I'll hand it over to Mark now.
Thanks, Terry. And one of the dangers of recording these videos is that I can watch as my sleep time go to bed routine. I can watch Greg and our past presentations, which is bad because I hear all the dumb jokes and self-deprecating remarks that I've made for 5 and 6 years running now. And so in order to mix things up a little, I've asked Leong, who's one of our newest partners at Damon, to kind of help shed her insights onto some of the recent cases coming out in the field of real estate. We've prepared a handout, which you should have been emailed, but it's also in the chat if you want to grab it from there. Our handout does have hyperlinks to the court decisions or blog posts which have the court decisions and as a tool or resource for you folks. There's a lot of content here. I don't think we're going to get to all of the ones we're going to talk about, and some of them we provide for your edification and reading enjoyment, but we will not discuss those here. I think that the most noteworthy decision about real estate in Hawaii didn't come out of one of our state courts this year, but rather came out of the Ninth Circuit Court of Appeals in an interesting First Amendment religious freedom type context. And so we're going to take the case out of order and ask Greg to cover that case. Greg.
Sure, thanks, Mark. So the first one we'll talk about is actually at the bottom of the handout. It's the Ninth Circuit decision that was released just a couple months ago, September 22nd of 2022. Ninth Circuit, the case is called Spirit of Aloha Temple versus County of Maui. And this is an interesting case for a lot of reasons. First and foremost, it's arises under the Religious Land Use and Institutionalized Persons Act, or RLUIPA, as we say, which is a law that governs or puts restrictions on when county land use ordinances can or how they should be applied to religious organizations. I think what's really interesting, this one comes out of Maui, and it's on, it involved ag land under the state land use scheme, but a parcel of 11 acres, therefore smaller than 15. So it runs through the county permitting under the state chapter 205. And in this case, the opinion starts out in a very strange way. It says that the property owner, as an individual by the name of Honig, engaged in all kind of illegal development activity on this 11-acre parcel, including grading and grubbing it, including altering natural stream courses, including building illegal structures, and engaging in unpermitted activities such as weddings and short-term rentals and other things. And when an opinion starts out that way, you think it's not going to go well for the property owner. But in this case, Mr. Honig formed a church, which he called the Spirit of Aloha Temple. And then he sought a special permit from the county to engage in many of the similar activities that he had been engaged in before, although now kind of under the rubric of a church. He went through the special permit process the first time, and it was denied by the county. He went through the second time. And this is a permit that's issued by the Planning Commission on Maui. The second time they denied him again, and he sued. Before I get into the important part of the case, I would just say there is some interesting discussion about process and when and how you get into federal court, and also what happens to your Chapter 91 administrative appeal. I would commend anybody to read the opinion to find out those nuances there, including a reservation of federal claims and so forth. But the bottom line was he was in federal court because of the federal cause of action under RLUIPA. The Ninth Circuit made an interesting comment about Hawaii's state and county zoning scheme as being confusing and complex, and it talks about the multi-layers between Chapter 205 and then the county zoning as well. And the Ninth Circuit, though, looked at this and said they treated this as a facial challenge because under the Chapter 205 special permit standards, there's a lot of discretion about whether the Planning Commission or the Land Use Commission, if it was a larger parcel, when they can grant or deny a special permit. And remember, a special permit is for unusual but reasonable uses on agricultural land. And in this case, the county denied it, citing impacts to the neighborhood. The Ninth Circuit, though, looked at the county ordinance that also applied to ag land, and that ordinance said that churches or religious organizations must obtain a special permit to operate on ag land. The Ninth Circuit treated that as a requirement that applied only to a church, and therefore it did trigger RLUIPA. And then the court went on to look at the criteria, or as the planning director called them, their guidelines. And the court concluded ultimately that not only should the plaintiff's RLUIPA claim not have been dismissed, but actually that they prevail as a matter of law. And that was because the standards under Chapter 205, which the planning director or planning commission needs to consider, were subject to unbridled discretion. And there was no firm guidance about when a special permit for a church could be issued or not. And because it was that unbridled discretion, they found that to be a violation of RLUIPA. And so it is an interesting case, and it's a new one, and Hawaii has a couple other RLUIPA type cases, but this is the newest one.
Yeah, thanks, Greg. Citing the when the Ninth Circuit Court of Appeals looks at your state's land use regulatory system and makes comments like that, it seems we might have some explaining to do as we bring these, or the government and the planning commissions might have some explaining to do if more of these cases end up in federal court. And federal court now is open after the U.S. Supreme Court's decision in Nick a couple of years ago. And so we went through about 25 years after the Williamson County decision came out that precluded bringing land use challenges into federal court in the first instance. And that has now been undone after the Nick case. And so I would expect that a lot more of these land use cases are going to end up separate, not RLUIPA ones, but land use cases are going to end up in federal court with interesting issues vis-a-vis Chapter 91 appeals and going to federal court without with or without going to state court with your administrative appeal. Okay, thanks, Greg. Let's turn back to our outline. Hawaii Supreme Court issued two decisions that we're not going to talk about. I'll mention them in brief. The Chun case relates to the licensure of commercial fishermen and their need to get a commercial fishing license in order without being allowed to enter into the state for immigration purposes. A lot of the commercial fishing fleet down in in Honolulu Harbor actually have liveaboard folks who are foreign nationals who aren't permitted to enter the United States, but are allowed to live aboard of this fishing fleet. And anyway, the interplay between that federal requirement and the state licensure is covered in Chun. It's a memo decision, but it's pretty fascinating in terms of the interplay between the governments. The next case is one that we've talked about before. It's another 30-meter telescope case, this one involving the transport or use of non-Hawaii County or state level licensed or state employee police officers. And so if you want to learn more about, we don't have Hawaii 5.0, but it looks like HPD is allowed to go to the Big Island to help. But if you have interest in that, you can take a look at the Flores versus Logan case. The next case is one I'm going to talk about, which is Community Associations of Kugle versus the Leeward Planning Commission. It's a case that arises out of Kona. Justice Wilson wrote the decision. This case was heard at oral argument when Justice Pollock was still on the bench, but he retired when he turned 70. The decision was issued by just 4 justices. As a side note, we have in the next year, there will be 2 justices who are going to be aging out of the Supreme Court. That's Justice Wilson, who's authored a couple of these decisions that we're talking about today, and Justice Nakayama. And so the complexion and makeup of the Hawaii Supreme Court is going to definitely change in the next year. I think CJ Rechtenwald has another year or 2 before he ages out. Anyway, in the Hulalai case, this is another special permit, which is a it's agricultural classified land. And in that case, a landowner back in 2000 sought a special permit to have an ag tourism type facility, a coffee visitor center. The permit was granted in 2000, but like a lot of permits, discretionary permits, there was a time frame in order to develop the property. And there were 2 extensions provided to the landowner, but by 2010, that permit had lapsed. That permit was conditioned on a drainage study. Thereafter, in 2015 and 16, the landowners sought and obtained grading and stockpiling permits, which are discretionary permits at the planning department level, to complete a flood channel project. They were also conditioned on a drainage study. Like land in Kona, how you handle drainage waters is a big deal. There were complaints that were raised from neighbors, we think, to the county planning department about construction activities on site. Specifically, there was an allegation that the landowner was operating a quarry and using the property as a equipment base yard. County inspectors went out and found a rock crusher, equipment storage area, and a junkyard. Under Chapter 205, a quarry for commercial use does require it's the zoning code, but the Hawaii County zoning code, but it does require a special permit to do quarry operations for commercial use in a ag zoned, an ag classified area. Quarry for internal uses would be permitted without that. So the county sent a warning letter to the landowner. The landowner then went to the planning department and applied for a special permit to operate a base yard and to crush rock for commercial purposes. That is a discretionary permit, and so it was sent to the Leeward Planning Commission and set for public hearing and contested case. The public notice did get disseminated and informed potential interveners of the right to seek intervention in that permit. A community association or a group of condo associations neighboring the parcel filed a petition to intervene. The landowner sought several continuances and postponements of the hearing before the commission. In the meantime, and I think that this little fact played large with the Supreme Court's decision, the planning director and planning staff went out and had several meetings and extensive back and forth communications with the landowner regarding the underlying violation of the operation of a base yard and rock quarry operations. After these visits and this back and forth, which were not before the Planning Commission, it wasn't an organized site visit by the Planning Commission, and the interveners weren't allowed to attend. The planning director found that the violations were actually, or the alleged violations were not actually well placed, and found that the underlying complaint of activities were actually permitted under the grading and stockpiling permits. So happy day for the landowner. The planning director says you don't need to have a special permit, and so the applicant withdrew his permit. But what about the petition to intervene, which was lawfully filed? The Planning Commission didn't act on that, and so the community groups appealed to the Hawaii Supreme Court. The Hawaii Supreme Court found it was an abuse of discretion to allow the withdrawal of the permit applications without ruling on the petition to intervene. But wait, isn't it moot because the landowner withdrew the application? There's nothing to contest or have a contested case. And there was no actual contested case ever heard. There was no evidence received under the permit application. And so though that is classically a trigger in order to appeal under Chapter 9114. The Supreme Court held, not surprisingly, that the case wasn't moot and that the underlying conduct that started all this, which is the allegations about the rock quarry and base yard, was still out there and needed to be resolved. Therefore, the case wasn't moot, which would deprive any court of jurisdiction. As to the contested case requirement, the Supreme Court held that you should have had a contested case on the petition to intervene. You didn't. One was required by law, and therefore we're going to hear it. It's interesting because denials of petition to intervene have a separate way to get up to that is in a decision where appellate courts do have automatic jurisdiction, but because they never ruled on it, I think that the Supreme Court was just going to say, well, we're going to treat that as the same. I think that the crux of this holding and the implication of this decision is important from a development perspective, because I think that most landowners and governmental agencies or permitting agencies treat grading permits, building permits, electrical permits, plumbing permits as separate discrete events that have their own, intervention or standing, or it's ministerial or it's discretionary, and they're handled separate and by themselves. And the Supreme Court in this case didn't let the landowner and the permitting authority out, despite the fact that both the permit applicant and the permit approver or denier had agreed that the permit was withdrawn. And so I do think that this case allows for a broader reach of folks, interveners, community groups, environmental groups, to seek governmental review over projects that are not just limited to the permit application. It's definitely one to follow as this area develops. I do think that the backroom deal flavor of ex parte conduct and the planning director, continuing while the permit was pending with the planning commission, the planning director dealing with the landowner, it was referenced several times in the decision. So I do think it colored the court's interpretation of that. Definitely a situation to watch. Okay, let's go over to Kauai, and Greg's going to talk about Waialeale.
Yeah, so the next three cases are Supreme Court decisions on environmental issues, and the first one I'll talk about and then pass it on will be Kiai Waialeale, and I'll get that wrong, but that's the group that challenged the Kauai Department of Water's final environmental assessment for a water relief line that would serve Lehui. And the challenge largely dealt with the fact that the water relief line was going to be larger capacity than what was being replaced. And the community group argued that therefore this was really to facilitate a larger development, specifically the master plan for Lehui for expanded development in Lehui. And it would also have impacts on water sources. And sort of cutting to the chase, we got more clarity, or maybe not, depending on how you view it, from the Hawaii Supreme Court about what is required to do environmental assessments. A number of years ago, we had that the Turtle Bay case about when you have to do supplemental environmental assessments. We've had the Super Ferry case about whether you look narrowly at the project or itself, or more broadly for secondary impacts. And this one deals with several of those issues, but also importantly, I think, which is a question of almost first impression in Hawaii, or expanded impression in Hawaii, segmentation. So the court held that the EA was not effective because the water department had failed in three aspects. The first being it failed to consider secondary impacts, saying that if the withdrawal of more water from the system was reasonably foreseeable by expanding the capacity of the system, then that should be considered as a secondary impact. In other words, that there would be further and future development in the area as a result of more water being available. The court also talked about the EA being inadequate for not properly considering cumulative impacts. Again, pointing back to the Super Ferry case, they said the environmental assessment was site specific. It focused on the area where this water line was going to be installed and did not consider the cumulative impact resulting off-site from an expanded capacity. And then third, it raised the question of segmentation, namely whether the EA was solely focused on this water relief line, or whether it should have, and therefore it was segmented from consideration of the expansion of Lehui itself, and whether that those were separate things or should have been considered or improperly segmented into two smaller projects, and therefore avoiding a broader or more global review. The court acknowledged that in the past, and it was the Kahana case, that they'd established a test that's established under NEPA, which is the federal statute as well, which is the independent utility test to determine whether a project's been improperly segmented for environmental review. And if that case, if you recall, was a small water drain installed under a county roadway, the EA looked just at the effect of the wastewater line under the roadway, but the court said that that had no independent utility from the subdivision that it was servicing. And so you should have considered the effect of the subdivision itself. In this, but that's the independent utility test. Does the particular project that's being reviewed have independent utility? Would it be done, or is it being done as part of a bigger project? In this case, the court clarified that test to say what we really meant to adopt was the multiple independent utility test, or dual independent utility test, where the test isn't just whether this water line would have been built anyway as a relief line because it was necessary and therefore it would have independent utility. But they said the court, the agency, and then subsequently the court should have considered also whether the expansion of Lehui, expansion of development in Lehui would have occurred without the water line. So you have to look at the independent utility of all other aspects that could be impacted. So I guess that's clarity on some of these things, or at least it's interpretations of areas where we haven't had the court speaking before. So that's the Kauai case. Sorry,
but that was an EA case, right?
Yeah. Mm-hmm.
So they're not saying that it automatically you had to do an EIS. They're just saying that you can't. We're going to adopt this test, and if it looks like it's part of a broader project, you're going to have to do an EA for the broader project, right? They're not saying that EIS was required.
They didn't say an EIS was required, but I think at some point, if it begins to look really massive, of course, that's the agency to make the decision about whether to require the more full-blown EIS rather than the EA.
Okay, interesting. We have another EIS or Chapter 343 case that I'll be handling, and that's the Carmichael versus Board of Land and Natural Resources. like the Hualalai case, it's another 4-justice decision after Justice Pollock retired. It was also written by Justice Wilson. And this relates to the East Maui irrigation system and the challenges that Alexander Baldwin and HCNS had related to their water irrigation system for East Maui. The actual appeal and the environmental assessment or Chapter 343 decision was the board's issuance of 4 revocable permits covering 33,000 acres of ceded lands water rights. That's the first sentence of the opinion, and so you can kind of imagine where the case is going. And so the question is whether the revocable permits required an environmental assessment under Chapter 343. First question is that I had was, should an annual revocable land permit require an environmental assessment? And in terms of scale, there are hundreds, I think thousands of these revocable permits. They're annual. A lot of the seawalls and that Greg has talked about in the past, or areas where a structure where the shoreline's emigrated and the seawall now becomes state property. There's a lot of driveways, next door neighbors. There's a lot of these revocable permits. And so the question is, does the statute which allows the state and the Board of Land and Natural Resources to issue these revocable permits require a Chapter 343 environmental assessment? Because my gathering from reading the case is that they don't do them, and this would be a major impediment to the board's use of these revocable permits to avoid problems with long-term leases, which have a public auction requirement. And so most oceanfront landowners would not want their seawall to be auctioned or to subject the land in front of their property to a private auction. Second question is 33,000 acres of water seems like a lot. The revocable permits themselves authorize the diversion of 100 million gallons per day for sugar irrigation and 8.6 million gallons a day for water use in upcountry Maui. Now, the lease was a separate deal. This was only dealing with the revocable permits, which were, all the parties acknowledged, were kind of a stopgap while the lease review got litigated. The issue is, in this case, the revocable permit statute, which is HRS 171-55, provided that notwithstanding any other law to the contrary, the Board of Land and Natural Resources may issue permits. There were no findings of fact, conclusions of law from the board, no public auction, no weighing of the public interest. So the question is, does 343 actually apply? This permit does involve, obviously, state and county lands, which is a classic trigger for Chapter 343. But the permit applicant tried to argue that the notwithstanding any other law to the contrary exempted revocable permits from Chapter 343, and the Supreme Court said it did not. And they remanded to the board to determine if another exemption to an environmental assessment might apply. There is an exemption for continuing of existing uses, which a decades-old water system might be able to argue. I think in order to address the concern regarding having to do environmental assessments for one of the hundreds or perhaps thousands of revocable permits statewide, the court concluded, and I quote, although the court is aware that the permits in this case were continued along with hundreds of other permits, we do not opine on the validity of other permits not before the court. Given the duration, magnitude, and nature of the uses authorized by revocable permits here, they may be distinguishable from other small-scale uses authorized by the board. So it's kind of an interesting thing because in Chapter 343, the statutory triggers and statutory exemptions are pretty black and white. There are some that get supplemented by the Hawaii admin rules, but it's usually not a court decision whether or not the exemption applies. And so it's interesting that the court in the decision was willing to interpret the notwithstanding any other law from 171-55 as perhaps having different meaning if it's a small use as compared to a big use. And so there is some kind of an outcome determinative, reading of the statute, but more seems to be more analysis and litigation is likely going to have to flesh this out because there are an awful lot of revocable permits out there. Okay, let's turn to Nalan and keep the North Shore country versus BLNR.
Yes, so this Supreme Court decision arose from a challenge to the Napua-Murkami wind farm in Kahuku. In order to operate the wind farm, Napua must obtain incidental take license as part of a habitat conservation plan approved by the BLNR. Keep the North Shore country opposed its application, basically citing the wind farm's potential impact on the Hawaiian hoary bat, which is an endangered species under both the federal and state law. Incidental take permit required by the Endangered Species Act is required for any take of endangered species or threatened species incidental to an otherwise lawful activity. Take here, has a special meaning to mean either harass, harm, or all kinds of ways of negatively impact the endangered or threatened species, or attempt to engage in such conduct. Napua took about over 2 years consulting with the U.S. Fish and Wildlife Service and the DLNR's Division of Forestry and Wildlife to develop this proposed habitat conservation plan. In its initial proposal, they want to build 8 to 10 wind turbines with a maximum height of 156 meters each. They said they will minimize the take by using a low wind speed curtail rate of 5 meters per second. This term basically means it's a process to set the minimum wind speed when the turbine starts to generate energy. And make efforts to fund the restoration of a nearby habitat for the bat, research on the bat to develop additional mitigation factors. The wind farm could take 8 federally protected species, including the Hawaiian hoary bat. After it was submitted to BLNR for review, the board notified the public, made the plan available for public review. And there's also required that the Endangered Species Recovery Committee has to provide input. They held public meeting, conducted site visit, and also worked with Napua to try to amend the plan. During this process, Napua basically proposed to somehow change the maximum height of the wind turbine to 100 meters. And then, in between, they try to address some other issues. The committee finally unanimously recommended the board to approve. One of the committee member, Dr. Gong, later was appointed by the governor to fill a vacancy on the BLNR. And so this matter then, came into further, for the Keep North Shore Country petition for a contested case hearing. The hearing officer basically recommended the board disapprove the plan, based on 3 factors. One is, the wind speed. They think 6.5, that low wind speed curtail rate would be more appropriate. And then, Napua also concluded the height of the wind turbine had no impact on the take. When they did the estimate on the potential take, they relied solely on data from the Kahuku wind project. Instead of the other one where, Kauai Loa wind farm, this one is preferred, or, the Keep North Shore Country group, they believe this data should be relied on. But the two, wind farm difference is, obviously Kahuku wind farm is closer location-wise to this current one. And then, but it has the wind turbines at Kauai Loa, it's much, it's larger, it's closer to the size of the proposed wind farm. But the Kauai Loa wind farm has much more bats there. So basically after, the additional briefing or arguments between the board in this, process, there's also, before the party started the argument, the board disclosed that they got a letter from one of the state senator. It was accidentally distributed to the board members, but none of them read it. And of course, on appeal, one of the issues raised by Cape North Shore Country is first that Dr. Gong served both on the committee and on the board. Sort of he tainted the process, sort of there's a bias there. The other one is this ex parte communication from the senator, although, the board, they made the disclosure, and at the hearing, Cape North Shore Country did not make objection there. So basically, this is a secondary appeal. The court started basically saying the agency's decision carries a presumption of validity. Cape North Shore Country has a heavy burden of making a convincing showing that the decision is invalid. They also find, because one of the criteria is the board has to utilize the best scientific and other reliable data available at the time. And the court thinks that is a mixed question of law and fact. And the circuit court properly applied the clear error standard in reviewing it. The court basically says they will grant significant weight to the agency's decisions based on technical scientific facts, because they have the subject matter expertise, are in a much better role than courts to, judge on that. And also it says the Endangered Species Act grant the board and the committee the authority to determine what constitutes the authority to determine, which resource to rely on, which one not to. For example, in the 2 wind farms, there is authority basically supporting the board's position of relying on the Kugle wind farm data instead of the other one. And as far as the committee, the committee member, Dr. Gong's on that challenge, the board the court said, there's no violation of any statutory limitation. It also does not raise any due process issues. The committee, the board member is, okay to also rely on information obtained while, they were serving on the committee. It basically, I think, is Cape North Shore Country didn't fulfill its burden of proof. They didn't, come up with more solid evidence proving the otherwise. But as far as the senator's letter, the court made some very interesting comments when, on the one hand, he said, because Cape North Shore Country didn't make the timely objection, they waived their right to challenge on this appellate level. But then the court said, nevertheless, we take the opportunity to reiterate that in future contested case hearing, BLNR could certainly do more to remove doubts on impropriety and build confidence in the permit approval process. We agree with Cape North Shore Country that the board should have at least retained a copy of the letter, even if it was prohibited from considering the letter's contents during the proceeding. That's about it. And let's move to the privacy rights, Mark.
Yeah, there were 2, let me just note that there were 2 foreclosure cases. The Ilima Lani condo case, cert was granted by the Supreme Court to review the ICA's decision from last year. That relates to homeowners assessments during foreclosure process. Interesting case that I'd like to talk about now is the State versus Kiana Aina case. It's a criminal case, but what's interesting about it is it discusses the what is a home, in this case a search warrant was obtained for a tent in a homeless encampment in Kona, and the police did get a search warrant, but if it were a house, the police were required to announce themselves, and they didn't do so. The police did go into the tent and found drugs, and so the criminal defendant tried to challenge it based on this kind of treatment that the tent was a house, and it was a split decision, 3-2, with Chief Justice Rechtwald, Justice Nakayama, and Judge Crabtree in the majority, with Justice Wilson and McKenna dissenting. And dissent did note that we have a right to privacy under Hawaii law, and would have more broadly defined the protections that a homeowner or a house owner would have obtained to include the tent. Okay, We're going to skip over the civil beat case. I think we did talk about the ICA decision last year, and it's a UIPA case regarding frustration of purpose. Frustration of purpose exemption, which is not statutory, is the subject of a major legislative effort that is ongoing, and so that'll be an interesting one to watch in the future. I'm going to talk about the public trust now. And over the last 20 years, the public trust has been a potent tool by which the Hawaii Supreme Court has exercised oversight over what was classically delegated land use and water use decisions based at the executive agency level. And in the Kelly versus Oceanside case, and then double down in the Kauai Springs versus County of Kauai Planning Commission case, the Supreme Court very broadly read the court's power invoking the public trust doctrine to wade into these agency decisions. This In re Miko or In re Maui Electric case, which came out this year, I think is a step back from the broadening of the court's public trust power into decisions. This case was, the decision was written or authored by Justice Todd Eddins, who is in prior practice a criminal law practitioner. It was a 4-1 decision with Justice Wilson dissenting. This case arose from a Public Utility Commission contested case, which had approved a power purchase agreement on Maui. The process that Miko undertook to approve the developers which were going to sell electricity to Miko was a competitive bidding project used to select different projects. It was a solar plus battery project that was approved, and the developer was going to use Ulupalakua Ranch land. A community group appealed the PUC's decision. The two issues that they were arguing were a problem was the use of an attorney to represent all of the finalists in the competitive bidding project. So Miko put out and says, we will entertain projects. I don't know the exact numbers, but let's say 20 people applied and 6 got picked. The 6 finalists were actually, they hired the same attorney to negotiate the power purchase agreement. And the community group alleged that or challenged that decision and said it was an antitrust, it was anti-competitive by using the same attorney who would negotiate the non-dollar amount or cents amount terms of these power purchase agreements. The Supreme Court was pretty quick to reject any notion that the antitrust, anti-competitive principles, which are out there and would have a problem with using the same attorney. They didn't, the Supreme Court said, we're not going to follow that with Public Utility Commission proceedings, that there were enough statutory protections to protect the public integrity and competition in the space, that they weren't going to adopt these antitrust principles in the PUC proceedings. So that's the simple issue. Next, the community groups challenged the Public Utilities Commission's fealty or adherence to its public trust obligations when it issued the decision approving the power purchase agreement. The Supreme Court kind of walked through what the statutory obligations or statutory mandate for the Public Utility Commission was in HRS 269. And then the court held that it reviewed the enabling statutes which give the PUC the power to make these decisions, to provide electricity statewide, to regulate public authorities, and then also to achieve the state's statutory goal of moving off of fossil fuels by 2045 at the time. The court, Justice Eddins' decision then says thus, and there's wordplay here, and you have to really pay attention to it. The majority decision says when there is no, let me take a step back. The community group challenged 2 aspects that potentially could implicate public trust resources. One was runoff from the site, and the other was the impact on willy trees, which are found in the ranch lands where the project was being proposed. So those were, there was an alleged impact on 2 public trust resources. The court, Justice Eden's decision, says that when there's no reasonable threat to a trust resource, the agency can just satisfy its statutory provisions and therefore, and I'm adding some words here, to fulfill the Public Utility Commission's obligations as trustee. When the project poses a reasonable threat, then the PUC must, or any agency must, assess the threat and make findings. And so the court held that there was no reasonable threat to public trust resources. Therefore, the agency only had to fulfill its statutory mandate. The PUC followed its statutes, and therefore there was no violation or no need to adopt the separate mantle of public trust trustee. The court kind of walked through the PUC missions and statutory obligations. It noted that the PUC was obliged to move off fossil fuels. And then the court held, and I quote, given the PUC's distinctive mission to fortify the state's power system while focusing on climate change mitigation, we declined to superimpose the water or land trust jurisprudence into the PPA approval context. Later, the court issued an order of correction which changed the word superimpose to infuse. And so when it mentioned the water and land trust context, I think it's referencing without cite the Kelly decision and the Kauai Springs decision. But I do think that after Kelly and Kauai Springs, there was a sense that the Supreme Court was moving into being a super regulator of land use and water and other decisions which implicate the state's public trust resources. And the Supreme Court in this decision took a step back and said, we're not going to read that into the PPA context. The court then adopted the test by which the PUC, at least, and perhaps other agencies whose decisions implicate public trust resources must follow. So, and in the Kauai Springs case, that case involved a reasonable allegation of harm in the decision, so that if there was a reasonable allegation of harm of a threat to public trust resources, then the agency couldn't just abide by what their ordinances and statutes and charter and constitutional duties were. They had to go and step into this public trust trustee role. This case changed that test, and it moved away from being a reasonable allegation of harm to being a reasonable threat of harm. And the court, and it couldn't just be an allegation. The court said, and I quote, reasonable threat does not mean there must be conclusive evidence of harm, but it means something more than vague and tenuous concerns about a project's surrounding environment. There must be tangible evidence that reasonably connects the threatened harm to the proposed project. The court then continued that the public trust duties were not, they were separate from the statutory mandate of agencies like the PUC, but then the court said, but they operate in tandem and can be coextensive. Now, we have commented about Kauai Springs and the Kelly decisions of public trust earlier, that it gathered power away from the agencies and the legislature to the Supreme Court, which is the ultimate and sole arbiter of what the Constitution provides. I view this as kind of cabineting the court saying, okay, land and water, okay, not power purchase agreements, and that it cabins off some decisions away from Supreme Court oversight under the public trust doctrine. The court was a little snippy with the intervener's argument that runoff and the impact on willy trees. And the court said, and I quote, hand waving without meaningful support cannot establish a reasonable threat. I do think that this means that community groups cannot just rely on complained about impacts or potential impacts, but that they were going to, as a threshold issue, that the agencies were going to have to require reasonable threats to public trust resources. Not surprisingly, Justice Wilson dissented and took issue with the PUC deferred or said that they were going to allow the land use regulators, which is the county on Maui, and would defer to their decisions about potential impacts arising from that sphere. And Justice Wilson thought that that was illegal delegation of public trust duties. The takeaway from this case is that the invocation of public trust is no longer talismanic, that it doesn't provide governmental regulators or those bodies to just, move beyond their statutory mandates into public trust areas, absent some showing of a reasonable threat to that resource. Okay. Next, we're going to talk about real estate industry, moving away from the government, and look at the prudential locations case. So Nalan, can you handle that one?
Sure. So the Ghanaian case is regarding the enforceability of confidentiality and non-competition, non-solicitation agreement. We're all familiar with the trigger standard. In this matter, locations admitted by deposition testimony of its president and VP of business operation that the sole purpose of their agreement with Ghana was to prevent new competition. And it's also undisputed. Locations didn't present any evidence or argue that there is any trade secret violation matter. So Circuit Court applied the trigger standard, held that this agreement is unreasonable, basically just based on it's greater than required the location's protection and do hardship on Ghana because she has 5 kids. The only means of support is from his new brokerage income, and the benefit to the locations is outweighed by the injury to the public. ICA issued a memorandum opinion, reversed that, but they didn't find any other address whether locations had a legitimate protectable interest. The Supreme Court basically, held that because Hawaii Chapter 480-4A provides every contract combination in the form of trust or otherwise, or conspiracy if it will restrain a trade or commerce in the state, then it is illegal unless it fits into one of the permissible restrictive covenants lawfully entered into ancillary to a legitimate purpose. So even if your agreement meets the trigger standard, you still have to prove it is ancillary to a legitimate purpose. And what constitutes legitimate purpose? Preventing competition does not. This case basically held that. It did mention some of for both non-solicitation and non-compete, some other permissible ones, basically, for example, for non-solicitation, workforce stability, customer relationships, those are legitimate ancillary interests. Of course, protection of trade secrets, proprietary information, that is. And the court also held for solicitation, it has to be actively initiate contact. Without that evidence, and then it wouldn't form. So that's this is about. The next one, it's a divorce case, Crawford versus Adachi. Dr. Adachi is a medical doctor with a lot of assets when she entered into the marriage, and the husband was broke. He owed money from child support from a previous marriage. And this guy is also engaging in several affairs during the marriage. And after he was caught in bed with another woman by his wife, he proposed to the wife, we're going to enter into a postnuptial agreement. If I ever engage in any infidelity in this marriage or, do any physical harm to you, then you will get most of our, marital assets. So the party executed that document. It went into family court. Guess what? Family court held the postnuptial was unenforceable because it violates the statutory policy and principles of no fault divorce in Hawaii. And basically, when the Supreme Court started reviewing this, it talked about, it just mentioned the family court does have this, agrees with the family court, of course, and also another issue on the the appeal is regarding family courts utilize of either the tax assessed value or a private appraisal report to determine marital asset value. Basically also said the family court possess wide discretion when determining the value of the marital assets. So that's about it. We're running out of time. So next, Greg.
Yeah, Greg, you want to just do the COVID-19 and then maybe whole Moana, and then I think we'll just end it there, allow for questions, and then if anybody has questions about the other cases, we'll go.
Yeah, sure. Real quickly, the COVID-19 case, we had talked about some of the early preliminary injunction rulings during the pandemic in some of our prior sessions. This is finally a decision now from the Intermediate Court of Appeals. It's called For Our Rights was the group. And we can be real brief. The Court of Appeals looked, this was a lawsuit that challenged the governor's emergency orders that were issued due to COVID-19 and raised the question whether under Chapter 127A, which is the governor's emergency powers, whether he could issue sequential emergency orders on the same topic, because the statute says an emergency order is valid for 60 days or less. And the court didn't have any problem finding that because of the broad and protective purposes of the emergency order statute, that nothing prevented Governor Ige from issuing these sequential, I think they referred to 21 that had been issued at the time. And that was not evading any limitation, evading a limitation on his power. And the court distinguished cases from other jurisdictions where the legislature reserved to itself the right to approve by resolution emergency orders. Hawaii doesn't have that. So clearly the legislature could change this if it wants, but it hasn't so far. Oh, and should we just jump right to Ho'omoana Foundation versus Land Use Commission?
Yes.
Yeah.
So this is another, well, it's an ICA case, and I will say it is a memorandum of opinion, but cert has been accepted by the Hawaii Supreme Court. So with the ICA decision, I think what's very interesting about it is it's another special permit for ag land. In this case, the permit sought overnight camping, either for homeless or as a commercial overnight camp. And community neighbors actually did an end run as the Maui Planning Department and Planning Commission was considering this. They went to the Land Use Commission and sought a declaratory ruling that overnight camps are specifically enumerated in Chapter 205A-4.5 as among those certain uses that are not permitted on prime ag land, which is land with a soil rating of A or B, like the property at issue. And the Land Use Commission came out with a declaratory ruling and said exactly that. The case was appealed, and I'll skip the circuit court, but up at the ICA, they said that the Land Use Commission's decision seems very reasonable, that if the legislature, when it said certain open area recreational uses are allowed on all ag land, but then some are not allowed on A and B rated land, then you shouldn't be allowed to give a special permit to allow that prohibited use on A or B rated soil. And the ICA said that makes sense. However, they said we have to follow the Supreme Court decision from the Mahaulepu case from about 20 years ago that specifically blessed that very process. That was relating to golf courses. And the Supreme Court said that even though a golf course was not permitted on A and B rated soil in the ag district, the county or the Land Use Commission could grant a special permit to allow a golf course. And even though the legislature came in a number of years later and took away that power for golf courses, it did not take away or change the law with respect to any of the other prime ag land prohibited open space uses. And therefore, they concluded that the Mahaulepu case still controlled and that you could get a special permit for an overnight camp on A or B rated soil. And as I said, the Supreme Court's taken cert. So the question would be, are they going to reconsider the Mahaulepu case? The other thing they might decide is that similar to the case that Mark mentioned earlier, there was an intervention petition that was not ruled on and that was deemed moot. But it wasn't the intervener that filed the cert petition. It was the neighboring homeowners associations who brought the original declaratory ruling. So stay tuned for that one.
Okay, we hit 1 o'clock. In terms of the remaining cases, we do reference the Fujimori case under liens that relates to Medicaid liens and estate planning. And if you do Medicaid planning, you really need to read that case in terms of how the court is going to interpret the Medicaid lien, which the state of Hawaii has. I think that's about all we have. The only other case that I thought I'd mention, and Greg can't talk about it because he's the counsel in it, but the next year will be an interesting with regard to the Seating County's ordinance of vacation rentals, and most of the counties have adopted various schemes or regulatory regimes to regulate short-term rental use. And so Greg's case in the federal court will be an interesting addition to the law of this area.
I think we could say, Mark, that the materials linked the preliminary injunction order.
Okay.
Yeah.
We can say that. We are willing to stick around if there's any questions, or if people want to put it in chat. But thanks on behalf of Greg and Nalan. This is a real treat for us. It really makes us brush off and look at all the real estate related court decisions that impact us. And so it's a real treat to meet with with your folks section, and hope all of you have a happy holiday season. Okay. There is a question about the title ones. And why don't I just say, the 3 title cases which we did cite are actually more civ pro-y, and they don't really relate to what, any meaningful substantive addition to the title. It was mostly about res judicata and burdens of proof on summary judgment. The one interesting one, and I think it's the Greenwell one, but don't quote me on that, relates to paper title. And the ICA had some very interesting questions and allowed a factual challenge to a paper title, to the assertion of paper title, and found that there might be an issue of fact. So I think classically, like most things in real estate title, one would think that you establish paper and you file summary and obtain summary judgment, and the ICA allowed a pro se litigant to potentially upend the ability to get summary judgment on a paper title case. And so it went back down, and so I'm reluctant to say that's what the law is, but it's definitely one to watch, and hopefully in the next year or two we'll see what the result is.
Yeah, I want to add that if you handle foreclosure matters, the Bank of New York Mellon versus LaRua basically deals with the same issue as the Nation Star Mortgage versus AOA Limalani condo. It is regarding who is entitled to the rental proceeds in a situation where the association foreclosed first and then lender's foreclosure. Between the time period after the court grants the MSJ till the time you complete the confirmation of sale, the finalize the foreclosure, in this period, who is entitled to the rental proceeds. So this one, because the court approved, the Supreme Court is going to review it, so there will be new ruling coming out.
Yeah, some of this is all still in the wake of the Great Recessions, and the condo associations non-judicial foreclosures, and so we're not done yet, but I do expect that our next couple years presentations, if we get asked back, will include additional discussion as the Supreme Court continues to take these up. Okay, Greg, do you have anything else you want to add? No?
Yeah.
Anything else?
Maybe the last one is regarding, like a residential sales, they all have the standard mediation clause there. So if you look at the case, Nakaoka versus Shizulu. So there, basically ICA said, it does not, the failure to mediate before filing the lawsuit does not, divest the court of jurisdiction, but it is a condition precedent for filing lawsuit, and then, approval of a motion for partial summary judgment or summary judgment is appropriate in that situation. That is definitely worth reading that case.
Yeah, I included in the materials because the Hawaii Associated Realtor forms are largely the ones that are used for all residential transactions. And this was the first time I had seen where they addressed, if you drill down into the dispute resolution provision, it doesn't have, there was mediation. And so this was the first time I'd seen the court handle or interpret the mediation provision, and whether or not it's a condition precedent, i.e. you cannot bring a lawsuit until you comply with it, or whether it's just one that, a defendant can invoke, like in the affirmative defense, saying, you didn't go to mediation first, we have to do that first. I think the court in that case said it was not jurisdictional. The court still has jurisdiction over the claim, but they did find that, the mediation contract provision was still required. Happy holidays to everybody, and we will all stick around if anyone has some last minute questions, but thanks for joining us today.
Thanks, everyone. Thanks, Mark, Greg, and appreciate it.
Thank you, Terry.
Thank you, Terry.
Thank you.